IDAC investigator Sesoko has finally spilled the truth during his testimony after he was grilled by Madlanga officials. If you are a fan of Madlanga Commission, watch till the end and see what happened.
Authorized in terms of that proclamation.
They would have been authorized in terms of your protocol, well,
Yes.
except for Project Golden and
Yes.
the speaker matter.
Yes, and of course the CI matters.
Excuse me?
And the CI
Oh,
matter.
CI matter. Yes, of course. All right, thank you. You can proceed with paragraph 44.
After the ID gave public testimony at the ad hoc committee, the volume of complaints increased. My own practice on receiving a complaint, whether a Section 27 referral or an email from the spokesperson, Mr. Henry Matumani, is to assess whether it falls within mandate. If it plainly does not, I respond or refer it out if the position is unclear. If the position is unclear, I meet the complainant to establish whether it falls within the mandate. And if it does not, I refer it to the appropriate agency. This would be done by way of a memo to the ID with recommendations. Of the matters I have received, I recommended only one for authorization. Attached MS5 is the register of matters that went through my office or I became aware of. Of the 27 matters that were recorded in the register, 13 of them were received by me. I only recommended one for authorization. Chief Oyi received 5 matters and Chief Perumal received 10 matters. At the time when the CI matters were authorized, I was on duty and no one was acting in my position. I went on sick leave on the 10th of November after I was kidnapped. Then Chief Perumal was appointed to act in my position until I returned to work on the 13th of January 2026.
Just to understand the matters that Chief Oyi authorized, when would that have been? My apologies.
Some of them would have been when I think most of them is when I was on leave. My memory serves me well. I think the register will be able to indicate, because it indicates when they were received. The MS5 would show when they were received, either by me or Chief Perumal or Chief Oyi, and what was done with those matters.
All right, thank you.
Can I just ask, what informs the decision whether matters get referred? They don't fall in your mandate, I accept that. If that is the decision, or the determination, but then you get to refer to other law enforcement. What informs referring or not referring matters to IPID? Because IPID deals with police corruption and similar. Is there a principal position that matters never go to IPID? And I ask because in the evidence so far about the crime intelligence matters, there are matters where it looks like on the face of it, until a final determination, that this could have been referred to IPID, because from what one understands of IPID's mandate, that particular issue may well have fallen within their mandate. Is there a principled position within IDEC not to refer matters to IPID?
Chair and Commissioners, the decision is based on the assessment. As we discussed before, that when it has to engage the IDEC mandate, it must meet the threshold of complex corruption or commercial and so forth, high profile. So even if it may involve members of the police, but if it meets that threshold, then it engages the IDEC mandate. However, if it does not, that's where then you have to refer the matter to those law enforcement agencies. As you'd see from the register, how I dealt with most of these matters. Some of these complaints, people complain that decisions were taken in the NPA, they were not happy with it. And when I assessed that, I realized that it does not engage our mandate. In fact, they need to do representation or things like that. Or some of the matters, people will say they went to IPID, they're not happy with IPID. You know, I would refer them to the management of IPID, that they be assisted there, or TPCI for that matter. I would refer them to the head of TPCI, exactly to avoid a situation where we take on the matter that are already in the space of other law enforcement agencies.
Let me ask more directly. A case that has been presented before us. You have the General Lushaba loss of laptop story, and the IDEC gets involved in and I'm really asking because I want to understand whether some of the problems that we have become aware of are the structural problems of competing jurisdictions, and therefore the one body ends up dealing with matters that they shouldn't. So if you exclude the gratification issue, you received a complaint. That's how it's, as I understand it. Mr. Adams filed a complaint and said General Lushaba lost his computer and there was a cover-up. That's how I've understood it to be, that there was a cover-up, and the cover-up goes to even his superior, even General Khumalo, even though General Khumalo was not his superior at the time. But the cover-up goes to General Khumalo, but also now someone took an affidavit at a police station and they misrepresented some things. Forget gratification for now. On the facts that I'm putting to you, would you still have said this is an IDEC matter?
If there was no issue of gratification and alleged corruption, it would definitely won't fall within the mandate.
Okay. Thank you.
Mr. Sesoko, you can continue with your affidavit. We are now dealing with the conflict between Advocate Ramsamy and Chief Perumal, paragraph 46 of your statement.
The conflict, the ID called me into a meeting to help resolve a conflict between Chief Perumal and Advocate Trushanta Ramsamy. As I understood it, the conflict concerned the approach to the case. Advocate Ramsamy, as a prosecutor, had taken a particular legal view with which Chief Perumal did not agree. The meeting was resolved on the basis that the parties should listen to one another, consistent with IDEC prosecutor-led model, and that the prosecutor is ultimately the person who must take the decision on the matter. This is how the issue was resolved. I must, however, indicate that in subsequent meetings where I was called into or brought to my attention, it appeared that these conflicts continued, and Advocate Ramsamy was concerned that as a prosecutor, her views seem to be overruled by those of Chief Perumal, and that the ID seemed to take more the side of Chief Perumal than her side.
Do you recall how many other meetings related to conflicts between the two took place?
I honestly cannot recall. They were varied. Sometimes Chief Perumal would come to me. Sometimes Advocate Ramsam would come to me. Would have a discussion with the ID. You know, so they were varied. I think because of that and the fact that Chief Perumal was not happy with Advocate Ramsami, ultimately she was also removed from the matters.
Did you not supervise Chief Perumal's work? I mean, if there was conflict between him and the lead prosecutor in the matter, because he reported to you, was that not an opportunity to then look at what he has done and supervise him and provide guidance?
Chair, we would have a discussion about these conflicts, as I said. And in the nature of how our project works, and it's also in the manual that all the discussions in relation to the project must actually happen at the level of the team, so that even when there are these disputes, the matters would be dealt with at the team level. So where you would have opinions of the entire team in terms of how the matter should be progressed, what needs to be done, what not needs to be done. And the deputy responsible for the matter would then take the ultimate decision if there is no amicable solution within the team. In this situation, unfortunately, the lead, instead of the DDPP, was the ID. So she would then take the ultimate decision on how the matter would proceed. So she would then overrule the opinions of junior prosecutors like Advocate Ramsam to say, this is how I want it to go. You know, I agree with Chief Perumal, or whatever the case may be. So that is how, in this specific matter, it turned out.
So the head of investigations is excluded from all of that. You don't play a part at all.
That decision making is that of the ID. I would not be included in that decision making. We can have a discussion, but you ultimately take a decision. This is how it is going to happen, and it would happen that way.
There's a couple of issues that I wanted us to go back to in your statement, and I'll try to do so thematically so we can move quickly. The first is short, and it relates to your annexure MS01. Just to note, commissioners, that there was a mistake with the labeling of the annexures, and there I take full responsibility. You'll see it starts with MS01 and then the next is MS1. But we propose to leave it like that. Alternatively, we'll go 1.1. But for now, if we can turn to MS01, and it's just a clarity seeking question regarding this document. This document seems to be discussing the secondment of investigators from IPID to the ID, correct?
That's correct.
When regard is had to it, I think it then lists the individuals to be seconded.
That's correct.
And then one of the annexures to it is that list of cases that's attached as Annexure G to this. What we wanted to understand is, as far as the dockets themselves and the movement of those dockets from IPID to the ID or IDAC as it now is, what informed that? Because this largely just speaks about the secondment of the investigators.
Chairperson and Commissioners, my understanding of MS-01 is that it records the correspondence between the former ID and the then acting executive director or directors, acting executive directors, both Mr. Sinne and Mr. Setsedi. But it records all other discussions that happened, including the issue of the handover of the dockets. At the time when this happened, I was in IPID. It was before my secondment to IDEC or ID.
All right. So you weren't involved in these deliberations?
Yes. So the deliberations happened between the two, the acting head and the head of ID at the time, Advocate Cronje. My understanding is that, as I testified earlier, that upon the proclamation by the president of ID, when the ID then, which is IDEC now, started operating, the first thing that the investigating director at the time, Advocate Cronje, did was to write letters to the DPCI and to IPID to request the handover of all the dockets that were related to state capture matters, that were related to Mbati and Nugent Commission as per the proclamation, but also requested the investigators who were working on these matters, because the ID at the time did not have its own resources. So they relied on secondment, or as the TPCI called it, duty reassignment of these investigators to the ID. And that is how all these matters landed in ID. So there were a number of cases that were opened when there was a lot of discussion about the state capture and the Guptas. There were a lot of dockets that were opened by civil society, by politicians, and so forth. So once the ID was established, then Advocate Cronje asked for all those matters, as long as they traversed the issues that were being traversed at Zondo to come to the ID. Now that list came as a result of matters that were in IPID and were dealt with at Zondo.
All right, thank you.
And are those the only cases that came over into IDEC, the ones that were traversed, that raised issues, also touched upon? And when you say issues, I take it you mean facts that related to these dockets that are now in IPID. The same facts arose in the commission, in Zondo's commission, or commission into state capture. Is that what you mean when you say they traversed those issues?
Yes, Commissioner. So, as I understand it, the investigating director at the time, Advocate Cronje, authorized, in relation to what they called security sector at that time, matters, authorized all matters that related to the testimony of Robert McBride at the Zondo Commission, but as well as all alleged procurement corruption that it's alleged to have happened within the SAPS and CI and the state security. So it was sort of an all-encompassing authorization.
Thank you, Mr. Sesoko. Then can we please move on to, let's deal with your involvement in the CI-related matters. Now, in your statement, the first incident or the first occasion of your involvement, you note the 6th of December as the first time, and this is when Mr. Rapesu calls you. Is that correct?
That is correct.
And you then say that he called you asking assistance to speak to General Jacobs regarding handing over dockets.
That is correct.
In your testimony earlier, you indicated that you did not know anything about the investigation, and what you did was assume that the investigation was authorized.
That is correct.
Why did you make that assumption and not check before making the call?
Chairperson, I think, as I said earlier, that I wouldn't expect an investigator to ask for Chief Perumal to instruct someone to ask for a docket from the SAPS if a matter is not authorized in IDEC. So that is why I had assumed